Well, let me tell your lordship the principle of impossibility, constitutional principle of, I just enunciate it. If there is a constitutional obligation to be performed, and it has to be performed, then in furtherance of that constitutional obligation, the principle of impossibility of performing another obligation comes in. Give your lordship an example. The term of the assembly is 5 years. Assembly is dissolved in 4.5 years. There is no assembly. And the judgment my learned friend cited, there is a presidential election or election of the vice president, and members of assembly have to vote. But the term of the assembly expires in 5 years' time. The constitution says you have to perform that obligation. So if the assembly is in dissolution, it's impossible for them to vote. That's the constitutional principle. Where is the obligation under 370? It has to be stated in the Constitution. You can't silently invoke it. And 376 probably 3 may, not shall. There is no obligation. That's the principle of impossibility, which has absolutely no application. How is it impossible, Malad? Why is it impossible? No, you've made it possible by acting the way you've done. That's the way to do it, Malad. Now, whether that's constitutional or not is a definite issue. But it's certainly not impossible. If you uphold it, it's not impossible. If you don't uphold it, it's only unconstitutional. Beyond that, your lordships are not asked to decide. So where is the question of impossibility? That's my answer, Malad. And the judgment that my learned friend cited, Malad, what's that judgment? In the presidential election is exactly that. Namely, the election had to take place, voting had to be done, the assembly was dissolved. So how could they have voted? The proclamation was there. So that's the constitutional principle. That's it. Now come to Malad to Article 3.
Yes.
So Malad, as far as Article 3 is concerned, Malad, let's assume I've made my arguments on the proviso already, Malad, that under 356 it can't be done. But now let's assume the proviso is not there. Let's assume that, Malad, all this is valid. Let's assume. Malad, how can they make the union, a state into a union territory? Under what provision of law? Okay, under which, what power? Then my lord put to them that there may be a situation of a national security situation. So therefore, temporarily, you may need to do that. But the national security situation is dealt with by Article 352 of the Constitution. 352 to 359 deals with all this. So how can you use Article 3 to do that? You can't use a power in 3, and of course that's not their case also. It's nobody's case that this was being done because of national security. Pulwama happened, Malad, in February 2019 during President's rule. And then they had elections in May 2019. And what is the justification of keeping, not constituting the state, Malad, for 4.5 years? Under what constitutional basis can you say that I will keep a particular state as union territory for 4.5 years? You say you are going to have municipal elections. You're going to have local government elections. There are a number of, the tourism has increased. So what's the impediment then? What's the constitutional logic, Mullahs, or basis on the basis of which you can deny the people of Kashmir a statehood, which and Mullahs, India is a union of states. As your Lordship rightly said, my Lord the Chief Justice, that a union territory can get the status of a state, but not the other way around. It's never happened in the history of this country. Actually, 272, 273, all this has never happened in the history of this country. Not even during emergency. So, Mullahs, this one last thing, and then I'm done. I want to show you the annexures in this, Mullahs. This is my argument on three, Mullahs. Others will deal with it in some form. I want to show just one. Yes, kindly see PDF 42. Now, this is dated 17th May 1949. But as your Lordship will notice here, and this is all documents are provided in the annexures, that at this point in time, Iyengar, Sheikh Abdullah, and Vallabhbhai Patel and Nehru were all getting together to draft 370. And on 17th May 1949 is a letter written by Gopalaswamy Iyengar, and he tells Vallabhbhaiji, here's the draft. Jawaharlalji has seen and approved of it. Will you kindly let Jawaharlalji know, direct as to your approval of it? No, directly tell him as to your approval of it. He will issue the letter to Sheikh Abdullah only after receiving your approval. Vallabhbhai Patel was the architect of 370. Nothing was done without his approval. In fact, he went to Parliament. Kindly see, there's another letter, another document here. 3rd November? Yes. It's very interesting with us. 3rd November. No, not 3rd November. No, yes, 3rd. Yes.
But look at Sardar Patel's letter at page 47, 46.
46, yes. Correct. That's the draft, Mullahs, of 306A. Kindly come to 244, Mullahs.
Right, that's that letter.
Thank you for your letter of 15th, which I have received only this afternoon on my return from the constitution. One second. I find there are some substantial changes over the original draft, particularly in regard to the applicability of fundamental rights and directive principles. You can yourself realize the anomaly of the state becoming part of India and at the same time not recognizing any of these provisions. I do not at all like any change after our party has approved of the whole arrangement in the presence of Sheikh Saab himself. Whenever the Sheikh Saab wishes to back out, he always confronts us with his duty to the people. Of course, he owes no duty to India or to the Indian government or even on his personal basis to you and the Prime Minister, who have gone all out to accommodate him. In these circumstances, any question of my approval does not arise. If you feel it is the right thing to do, you can go ahead and do it. Now see the next document, 3rd November. There was some, again, this is by Vallabhbhai Patel. There was some difficulty about the provision relating to Kashmir. Sheikh Saab went back on the agreement which he had reached with you in regard to the provision relating to Kashmir. He insisted on certain changes of a fundamental character, which would exclude in their application to Kashmir the provisions relating to citizenship and fundamental rights and make it necessary in all these matters as well as others not covered by the accession to 3 subject to seek the concurrence of the state government, which is sought to define as the Maharaja acting on the aid and advice of Council of Ministers appointed under the proclamation on 8th March 1948. After a great deal of discussion, I could persuade the party to accept all the changes except the last one. He was the one who was interacting with the party. And he was the one who finally, Mullahs, persuaded the party to accept all the changes except one. And of course, Sheikh Abdullah thereafter.
Sure, there was a political compromise to ensure enough flexibility at later
absolutely. All I'm saying is that everybody was part of that process.
You are accepting the second part also, that there was flexibility to ensure that in future it works itself out.
That's correct. Well, all that I'm saying is, Mullahs, they were all collaborating. The key players were collaborating in drafting 370, and this is how they understood 370.
That argument you have already
I've already made. I'm not repeating it, Mullahs. I just wanted to read these letters. So, Malas, and then I've got this table, Malas, of Jammu Kashmir, Malas, where Jammu Kashmir is ahead of most of the states in India in every parameter. But we are not concerned with that, Malas. I just put it. So that's all I have to say, Malas. I just want to say at the end that, Malas, as I said, Malas, your lordships, Malas, ultimately is the arbiter of what this constitution should look like and how it's to be interpreted. But I only want to request your lordships to think of one thing, that as I walk out in silence of this court, let the court speak on behalf of the people of India. Because this court, this government, or any government, any administration acts for the people of India. And it should not be that acts are done when a part of the people of India are silent, who have never been consulted, and whose fate will be decided by the cabinet sitting here without reference to parliament, without reference to legislature, without reference to the people. Those people are central to the Constitution of India. We should not forget that. Thank you very much for giving me this time.